life. Staying away from alcohol would be great, and he understands that. I think probation would be really important to him, so he gets a period of oversight and gets some substance abuse kind of treatment of some sort, and he has that oversight while he's there. I understand that the previous OWI did not happen that long ago, and likely there's going to be some jail time with it. However, I'd like the court to look at his demeanor with his evaluation, the fact that he's really looking at this and saying, you know, I see the problem. The problem was me and my substance use. And so I'd ask the court to sentence accordingly for that.
Thank you. Mr. Bryant, is there anything that you want me to know?
Yes. I was just wanting to say that I learned never to get into a vehicle after drinking. Well,
anything else you want me to know?
well, my health is getting better. I've been going to doctor since last time I talked.
I'm not picking you up, Mr. Bryant. Mr. Bryant, I see your lips moving, but I'm not hearing anything that you're saying at the moment.
Oh, you know?
Very lightly, very little.
Well, I was just wanted to say that I regret doing my decision on that night. I put a lot of other people at risk. Regret that. That's what I have to live with every day, and it's really gets to me. I take my life seriously and other people's life seriously. I'm here so I know how people react. It's a job, part-time job. And I keep on keeping on with that and my health.
All right, thank you, Mr. Bryant. How long were you on probation for your first drunk driving conviction in 21?
6 months.
The criminal history report says 18 months.
Okay, well, it's 18. I can't remember that far back.
That was 5 years ago.
I'm having trouble remembering right now.
Why did you keep drinking after this incident? Your report from the substance abuse evaluation says that you didn't stop or haven't stopped drinking until June.
Oh, again, it stopped. I was just freaking, and I had urges. It's my fault. I understand what I did. I asked the doctor to put me on medication so it could help me with not drinking.
Okay, but the question was, why did you not stop until June when this incident happened in January?
I don't have a good answer for that because it's my own fault, my decision. But I need help for this stuff. I had her just being honest with her.
I don't doubt that you're being honest with me, but my concern is that you don't understand the depth of the problem. You're thinking that you can fix this problem by simply not getting in a car after you drink. My view is you need to stop drinking. This is your second drunk driving, and you could have very easily killed yourself or somebody else because it's obvious to me that you had no idea that the roundabout was there. That's being so drunk that you have no idea what you're doing when you're driving. That's a guided missile waiting to explode in somebody's life. And you're just darn lucky that it didn't hit anybody.
Right. I understand.
We wouldn't be talking about whether or not you go to counseling or not. We'd be talking about whether or not you go to prison or not. Your blood alcohol level was almost twice the legal limit. Do you understand that?
Yes, Your Honor.
Is there anything else that you want me to know before I decide what to do?
Oh, Your
I'm going to put you on probation for 1 year simply because I don't think that you've yet figured out that you have to stop drinking. So I'm going to use the probation to keep you from drinking for a longer period of time. There's a $75 crime victim fee, mandatory $50 justice assessment. There's $245.65 in restitution to Gaylord City Police Department for their investigation of this matter. There's $300 in court costs, $200 in fines, and a local charge of $15. There's a $360 probation oversight fee. Let me add those things up for you.
For the court's original sentence. If your violation is that you've committed another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, Your Honor.
But it's not mandatory that you're sent to prison. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, as you found out, the court has the authority to extend the term of your community control or to impose additional more severe sanctions, which can include local jail time or ultimately prison. Do you understand that?
I do, Your Honor.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
I do.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
I do.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
I do.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
I do.
Do you understand that a plea of guilty is a complete admission of your guilt, and the court could proceed to judgment and sentence?
I do, Your Honor.
This is how you wish to proceed?
Yes, Your Honor.
All right, Ms. Tranter.
Your Honor, this occurred April 22nd, 2026, Warren County, State of Ohio. The defendant on that date, with purpose to deprive the owner of property, knowingly obtained or exerted control over the property without consent or beyond the scope of the express implied consent of the owner He was wearing a TAD monitor placed by Community Corrections, received a weekend day pass from his sober living, did not return and cut his TAD monitor off. Restitution value is $1,000.
Mr. Clark, anything on those facts?
Nothing on the facts, Your Honor.
Mr. Walker, did you hear the statement that she read?
I did, Your Honor.
Do you admit that what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up when you enter a plea of guilty?
I do.
What is your plea?
Guilty, Your Honor.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Mr. Clark, as to the probation violation under 43114, does your client wish to have a hearing?
No, we will admit to the ILC violation.
All right, Mr. Walker, on that case, you understand you are entitled to have a hearing?
Yes,
You wish to waive that hearing and admit to the violation?
I do, Your Honor.
Okay, on case number 43114, the court is going to terminate your ILC. And based upon your plea of guilty on February 25th of 2026, the court is now going to find you guilty. Now, with regard to sentencing on both cases, Mr. Walker, Mr. Clark, do you wish to be heard?
Yes, Your Honor. My understanding is probation is recommending a CBCF for the defendant. Mr. Walker has told me that he's okay with that recommendation and that he is able and willing to engage there and handle his business there. Regarding, I obviously wanted to note for the record, he did successfully complete the one class and the one program that he was supposed to. I know he was transitioning over into a sober living. That's where things went south. This is his first violation, even though he hasn't been on very long. Just ask that the court adopt the recommendations of probation. And the only other thing to address is, depending on the condition of the TAD monitor, the defendant tells me he knows where it is and knows how to get it and knows how to get it in the hands of probation. So would that alleviate some or all of his restitution?
Okay.
That's the question.
Mr. Walker, is there anything you'd like to say?
Not this time, Your Honor.
Mr. Walker, I got to be honest with you. At 45 years old, you got to grow up. I mean, these are just really, really poor choices. You don't have a great record. It's not the worst I've seen, but it's not great. And we're trying to help you here, but you just seem to be fighting against helping yourself. And I don't understand that from where I'm sitting. And again, I understand that addiction can be difficult. There's going to be slip ups, but you know, we're trying to help you here, and you're fighting against us. So I don't understand that.
Well, can I say something?
Yes, sir.
Not too long, at the end of 2023, beginning of 2024, I lost both of my parents, and I was the one that found both of them. And it kind of entered a point of isolation in a spiral. But since then, I've sought help with local church in Vandalia, where I'm a local to Montgomery County. So I've been trying to make some forward progression, but there's been some, as you can see, with our recent encounters, there's been some slip ups to fall back. But I feel personally that I've been making some good strides toward it, considering the losses that myself and my brother went through. But that's still no excuse by any means.
All right, I understand people deal with grief differently and when situations arise, but again, you have to make better choices, especially when, the original case is a theft case. The restitution the victim must be made whole.
Yes.
Obviously, community corrections is another matter. We will talk about that at some point. So with regard to both cases at this time, the court is going to make a finding that you're still amenable to community control, because I want to try to help you.
Thank you.
So I'm going to place you into community control in both cases for periods of 3 years, subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Okay?
Yeah.
I am going to order you to successfully complete a community-based correctional facility with any recommended aftercare. When you are released from that program, you're going to be placed on electronically monitored house arrest for a period of 90 days. You cut this monitor off, we won't be having this discussion another time.
Nope.
At this time, I am going to order restitution to community corrections in the sum of $1,000. However, if the equipment is returned and it's in satisfactory condition and not damaged, I can amend and address this at another time, okay?
Your Honor, is there a time frame on that particular return? Because I mean, I know where it's at now, but as I spoke with my attorney, I don't have my girlfriend's new phone number.
Excuse me, I'm sorry, your girlfriend's what?
Her new cell phone number. So I mean, I can get to that within, you know, it's a matter of Googling it or looking at or having somebody look it up, but I don't have it.
Yeah, and she hasn't reached out to you at all?
Here?
Yeah.
No, she has not.
Okay.
Not yet.
I'll try to get a hold of her and see if you can get that equipment returned. Obviously, I'll take that into consideration and we'll have it inspected, make sure it's still operational.
Okay.
Yeah, that'll suffice, but
It's in
again,
the trunk of my vehicle, which is at her property. So I know it's in safe storage. And when I removed it, it was the band. So the band will be.
no, I understand.
Yeah.
Those are disposable.
Yeah.
All right, so
Thank you.
the restitution order will be $1,000 to community corrections. You still have $387.60 to Brenda Fraley that's still owed. The court will find that you're indigent for the purpose of any fines, costs, or other financial sanctions at this time. If the equipment's returned, I can revisit this restitution order on the new case at that time.
Okay.
Now, you're also subject to the discretionary post-release control if you're sent to prison. Do you want me to go over that with you again?
You don't need to, Your Honor.
You have 123 days credit, jail time credit. That is all going to be assessed on the first case.
Correct.
Okay? Case number 43114.
Yeah.
You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days. I'm sorry, I'm writing down here what I did. You must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have questions for me?
No, Your Honor.
Let's get this right, okay?
I agree. Thank you, Your Honor.
Anything else, Ms. Tranter?
No, sir, thank you.
Anything else?
Thank you, Your Honor.
All right, that's all.
Do you need it for the retreat or who?
Yeah.
Okay, let me call them really quick.
Yeah, I can't remember who, but I can't
because
remember if it was a
sometimes-
TAD or an EM. But
It
one
was a tad.
Okay,
It was a tad.
one was something different from community corrections.
Yeah, he doesn't have the address. We already asked for it. Hey, it's Abby. For a TAD
See you, Jesse.
report,
Take care.
for a TAD monitor, does
Sir?
the or
Yes.
restitution,
I'm hearing impaired and I
does
need a
that go
hearing
to
device. for
you guys or
the
does it go to like the
court.
TAD?
Okay, just talk to Mr. Logston there.
Yep, we'll wait a second, find out if it's gonna go on the record or not yet. They'll meet in chambers, but we have one if we do anything in the courtroom.
Justin, we're still on.
Elisa Adams, where are you? Elisa, that's you?
Yeah.
And Langston Adams is still your attorney? Is that, okay, have you seen him today?
Here, Judge.
He's back where? There he is.
I'm working.
What are we doing on Miss
Just, I talked to the prosecutor, Miss
How'd
Adams.
that go?
Oh, fairly well.
Good.
We're just to reset on her, just one, Judge.
I don't agree with him. I'm just looking for your response, your reaction.
Thank you.
Well, it's. Whoa, mama, that's an old one, huh?
Well, I just got on the case recently.
Well, okay, there's an MTRP. This was originally filed back in 2020, the original indictment.
Yes, sir.
6 years ago. And she's been on probation since 22.
Yes.
And deferred or unadjudicated probation. And see, we've got a motion to revoke probation filed in June, alleging
Yes, sir.
represented by Mr. Barbado. We have Mr. View from the prosecutor's office, Officer Henry from probation. We are here today for a final violation hearing. Mr. Barbado, does your client wish to have a contested hearing in this matter?
Your Honor, Mr. Rader does not.
Mr. Rader, do you understand the rights you're giving up by admitting to this violation?
Yes, sir.
Is this what you want to do?
Yes, sir.
Do you admit or deny that you violated the terms of your community control?
I admit.
Based upon your admission, I find you have violated the terms of your supervision. Mr. View, anything on behalf of the state or on behalf of the victim?
Your Honor, as far as I can tell, we have not had any communication with the victim in regards to the probation violation. From the state's perspective, Mr. Rader has an opportunity at judicial release following conviction for abduction, a third-degree violent felony, domestic violence, a fourth-degree felony, violent felony, and 10 violations of protection orders, all of which indicate at that point that he is a danger to the community and to the victim and is unable to comply with the court's orders related. The court gave Mr. Rader, I think, an opportunity at judicial release to prove that he could, in fact, follow the court's orders, that he could take advantage of the services of supervision. And we're back now on a second violation of the same nature. He was before the court last summer in 2025 with violations for using methamphetamine. From the state's perspective, that in and of itself is the kind of conduct that creates a danger to the community and to others. I think as the court noted that his methamphetamine use really was underlying cause of these violent felonies. The court at that time last year extended his probation and increased the level of treatment to residential treatment. So the court has already given him opportunities at other treatment options to continue his supervision. He continues to not follow through with those directives of the court and to comply with probation. I think he's been uncooperative with, he's failed to appear for his drug testing. I don't think he was being honest with his probation officer about his continued use. And from our perspective, he's demonstrated that judicial release is no longer the appropriate direction. Our recommendation is that his probation be revoked. He be returned to the institution for the remainder of his sentence.
Mr. Henry?
There's nothing further than what we had spoke about. We currently do have 2 placement options for CBCF if that route is chosen.
Mr. Barbado?
Thank you, Your Honor. If I may.
Go ahead.
Your Honor, I have prepared a written sentencing memorandum. I would ask if I do have permission after today's hearing to file that just to conclude it in the record.
Sure.
I will not belabor the court with having to hear my long-winded arguments as it relates to the sentencing decision. I will just indicate very briefly, and speaking with Justin, I noticed from the first time that I spoke with him to the last time, even in that amount of time, knowing what's at stake and realizing what he possibly could stand to lose was a difference. It was a different individual that I was standing before when I was at the jail, speaking with him honestly and earnestly, and it took some work to get there. But in getting there, we did recognize and analyze 2 very specific factors. One is what would be best to protect the public from future crime, and 2, what would promote the least burdensome but most effective rehabilitation, which are 2 of the overriding principles and purposes of felony sentencing. And just very succinctly, as it relates to those points, Judge, as the state has indicated, and even as the court has acknowledged, drug usage has been a rocky road for Mr. Rader, and in fact has been a precipitating factor that led to the incident that brought him here. I do know from my time at the state, I communicated with OSP a number of times about cases where drugs were getting into the prison. Mr. Rader himself acknowledges that is an honest reality that we do have to face. I think to get him out of the environment in which he would be tempted or bad influence have affected him negatively, the most important thing for him was to continue on the right path.
to make sure he's held accountable, to have an opportunity to learn and figure out ways to cope, to strategize, to figure out what to do to avoid those situations, and to not be surrounded in an environment by people who might otherwise tempt him. In addition, while he's been out, he's gotten full-time employment. I have letters from employers, 2 different employers, talking about what a paragon of what they want to new employees to be like, how he's been on time, he's been there, committed to it. That in and of itself, I think, is another thing that gives somebody structure, holds somebody accountable, and provides them healthy, safe options to get their minds off of their addiction and get their bodies outside of the environment in which this can happen. In terms of the principles and purposes of felony sentencing, Your Honor, I do believe sincerely that after talking with him, he will take it seriously. He recognizes the times of excuses, making excuses, denials, and putting the blame on other people other than himself are over. He has only himself to blame for the current predicament he's in. He accepts that, he acknowledges it, and he now wants to be honest with himself and honest with the court and the state, the victim, and myself. To those ends, Judge, I think all of that could be accomplished if given a shot at a community-based correctional facility, if given an opportunity at treatment, which we do think would promote safety for the community and is the least restrictive punishment, as well as the most effective path towards rehabilitation. Thank you.
Mr. Rader, is there anything you want to tell me?
You
don't have to stand up, Mr. Rader, you're fine.
Sorry. I'd just like to accept responsibility for my actions, Your Honor, and I just pray for leniency that I can go to a community-based correctional facility.
So here's where we're at on this case, Mr. Rader. At some point, this case becomes a protection of the public case. It doesn't really have much to do with you. You either can do the work and get sober or you can't. And it's not about giving you chance, giving you opportunities. That's not really what this is about. This is figuring out the best way to keep my community safe. And I think the best way to keep my community safe is not to throw you in prison for as long as we can, because eventually you're going to get out. I think the best thing for my community is to try to fix you and to take care of this drug problem. You need to do the work. And if you can't get that done, we are really running out of options in the case in terms of what we can do. I'm going to continue you on probation. I'm going to order that you enter into and successfully complete the community-based corrections facility. Plus, you're to be on 60 days of electronically monitored house arrest after your release. And you're going to comply with the random call-in. We're going to continue to supervise the case. I know you don't live around here, but that's the price that it's going to pay. I'm not going to send this to some other county and wonder who they might assign to it. I'm going to assign my officer to it that I know is going to keep a close eye on this so that we can figure out whether or not you're actually serious about beating this. If you're not, we just need to do the math, add up the days, and you just do the rest of them and hope for the best when it's over.
Sure.
Anything else we need to do? Anything I forgot?
No, Your Honor. No, Your Honor. Thank you.
All right, you are remanded to the custody of the county sheriff pending transport to the facility. Good luck to you, Mr. Rader.
Thank you, Your Honor.
200.
Violations, and the defendant's been on deferred or unadjudicated probation. Yeah. Okay. So what are you asking for?
Just one reset over.
How much time are you talking about?
2 weeks.
8 years?
I'm not
Not 8 years.
not opposed to a 2-week reset, Judge. We've extended an offer.
Is 3 good?
That's perfect. 3.
We've extended an offer.
Three is perfect. Yeah. You offer 5 years TDC so on the MTRP. That was the offer.
Okay. Well,
I know
y'all try to work it out, and if y'all can't, then we'll have a hearing. That's what we do.
That'd be fine.
But let me know. But in 3 weeks, if y'all can't work it out, we're going to go into a hearing on it. Okay.
Yes, sir.
All right. Good luck. Thank you.
So he's still on the tab?
Yes, already 6 seasons.
Okay.
Do you need a
because he already signed.
I said,
Mr. Bennett?
He already signed. And he's here. And I do have his grandmother here, right?
yes.
Yeah. I already sent it.
It's not on there. It's not coming up.
I'm 100. You have to go back to the date that we were in.
Oh, I see. That makes sense.
Yeah, I'm 100% sure it's there. Yeah.
What date?
That's more than 99.
Let me check my thing. I can tell you the date. Yeah, the paperwork is done. We already signed.
Okay.
Let me-
You're leaving now?
Yeah, I already know.
There he goes. We'll never see him again.
Judge, we did the 5-year capital now.
Okay, as soon as I figure out.
Good Lord.
It's on.
Langston, you're on a bunch of these here today, huh?
Yes, sir.
Okay.
Yes, sir. I'm gonna tell you right now.
Yeah, okay, we got Bennett next.
We were in court last on 16th, 20. So check that date.
Then we've got,
pop up.
what are we going to do on Jasmine Dudley?
She's here. I think that's going to end up being a hearing.
Well,
Judge,
are we going to do it today?
Yeah.
No, not today, Judge. I'm not prepared. I received the information I needed to file a motion
Hearing.
yes, I received it and we filed an amended MTRP yesterday. He filed it and served it on Mr. Adams just yesterday.
What is it alleging that's different?
We added a new offense, Judge.
Hey, do you have a copy of it?
I have mine.
Where is Mr. Dudley?
I didn't see it.
Is Mr. Dudley in custody?
Yes, sir. She's here.
Oh, it's Jasmine. Oh.
She's here. Look, let me make a copy of that in the back.
I emailed you.
I'm not saying you.
But I have a motion filed in January. I don't have.
We e-filed an amended yesterday, Your Honor. When I received the information. As soon as I received the information.
What's the
commit the offense of assault on a public servant in December of 25?
And then I think.
What happened on we didn't, that information, I guess, wasn't received.
I just got it yesterday.
When you filed that motion in January?
I wasn't the prosecutor in January, Judge, and I just.
Yeah, I'm talking to you. I mean, the state, the DA's office.
Yes, sir.
But
it's a new offense.
So, okay. Has it been filed independently as an individual case in a court or anything else? Has it been indicted or an information been filed on it?
It has been, Judge. I have a cause number here of 26DCCR 0428.
Okay, so it was filed as a felony, huh?
Yes, sir.
May I?
Yes, sir.
Copy of that? Have you seen that?
I know about the 2 cases. I didn't know about the amended MTRP.
Thank you.
I just printed out a copy, Langston.
Thank you.
Probably March. Maybe.
When he filed yesterday, I haven't seen the email, so I got to pull it up on my email.
Well, I can clarify. It should have been served, e-served.
Okay.
When last night?
Yeah, yesterday.
I haven't boarded it yet. I'm not saying you didn't send it. I just didn't. Yeah.
Okay, so in this particular case, so far, the amended motion has not been filed yet.
It's filed yesterday.
Yesterday.
Thank you.
Here's a copy for Mr. Adams. We'll get it processed today. It's just filed yesterday, Judge.
Where's my copy?
Well, here, you can take this for right now.
No,
You didn't want
mine.
Not
yours.
Copy, Judge. Just give me a second.
No, not yours. Hey,
Give me 2 seconds, Judge.
thank you, sir. I'm copyless.
Copy.
You know, walking around town like that.
It's not.
Where's your copy?
That's not good.
I don't have a copy. Well, you're copyless.
Hey, you can't beat that.
That kind of, you know what, that kind of stigma.
Well, thank you. Oh, that's original. Give it to him.
Who's on first? Who's on first? Yes.
What's on second?
There you go.
I don't know what's on third.
It's Jasmine Dudley. Jasmine Dudley.
And
All right.
we just added the new offense.
All right. Follow the press.
Just to make it clear, the defendant is on probation, correct, for harassment of a public servant, a 3rd-degree felony?
Yes, Your Honor.
And then it's alleged that, number one, she committed the offense of aggravated assault on December 20th, failing to immediately report to probation officer a new arrest. failed to never become intoxicated as being intoxicated on or about December 21st, 2025. Was at a location other than her residence. It says her residence at approximately 10:50 p.m. on or about December 21st. And finally committed the offense of assault public servant on or about December 21st. How many assaults were committed that night?
Well, there was one assault on the 20th, December the 20th. And my understanding of the allegation is while she was in custody, the following day was when she assaulted the
okay. So two separate assaults on two different events.
That's the allegation, Your Honor.
And she's on probation for harassment of a public servant, right?
Yes, yes.
Which was alleged. Did assault, harass, alarm, or cause person known to be a public servant, a Baptist hospital employee, to contact the saliva of the defendant? So she spit on someone who is attending her medical care?
An emergency room technician.
Okay.
But Judge, in fairness to her,
I'm just looking at what the allegations were here. We hadn't gotten to the whether it's true or not, except she did plead guilty to harassment of a public servant and was placed on probation. So I mean, that's a finding, but the others are still to be found. What's her bond on this?
I do not know offhand, Judge.
I mean, these are assaultive offenses, and she was on probation for assaultive. Generally, the bonds are high.
Judge, I have here the PC affidavit. Well, I don't want to miss it. Well, I do have the PC affidavit for the most recent alleged assault of that correctional officer. If the court's interested.
So, Judge, on the MPRC, her bond is $100,000.
Right.
Who posted $100,000? You got that money?
No, she didn't.
My family helped me.
Okay, so you have access to that. Are you appointed?
Yes.
You need to be hiring your own lawyer. Well, the taxpayers aren't going to be paying for your legal defense when you can come up with $100,000 bond, man. That's an order. You're going to pay him. He's a great lawyer, but I'm going to make you pay him for what it costs for the people to pay for your representation when you can find $100,000 bond. If you have access to that, you're going to pay for the lawyer fees. Do you understand? That's only fair to the people of Jefferson County. They're not going to pull that.
And then, Judge, her bond on the 26 DCCR 0428 is $25,000.
Okay, so you posted $125,000 in bonds.
But just put that into context.
I did.
Well, I just want to add something to what's your name again now? Michaela, can you come up real quick? She's a representative of the state of Texas. What Michaela is the CPS worker on a case, because when it's not a hearing.
Well, Judge, it's morphing into a hearing here, and I'm not prepared to.
What are you intending to prove here? So get to the bottom, so I'll decide whether we're going to have a hearing. What is that lady here for?
We're mentioning about the bonds, right? And she has a rich history of psychological issues.
She has a rich ability to get money too.
Right. And I also remind the court that Dr. Rapon did evaluate her. He determined that she was competent. However, he did mention about her mental health issues, that she does have mental health issues that she's been treated for.
Okay.
The reason that CPS is that part of when you were setting those bonds, she also, and Mr. Coleman knows this, I'm not surprised because it's in his discovery. In the discovery that was provided by the state, they mentioned a CPS case, and that's in their discovery. Yeah, it is. It's mentioned in but here's where I'm going.
Where are you going?
So here's where I'm going with it. Yes, it's in that discovery. So I'm not telling him something you don't know. CPS was in favor of her having a bond to be able to get to her kid, because as it was going through the case down there.
That's okay.
Right.
But it's still, I'm sorry, but it wasn't their decision. It was mine. I made the decision.
No,
but I want to hear as much input as possible and make a fair disposition. So, but what does that have to do with anything else?
Well, here's the point that I'm making. Yeah. When the court was talking about $100,000 and $125,000 bond, part of that is that CPS wanted her out on this case so she can get back to taking care of her child.
Okay.
And what
I made the final decision.
No, you did.
Okay.
But what I'm saying is that she had to hustle and gather resources, and that's why McKenna can tell you that.
So everybody,
and she's here to say that.
Well, she's got that. Well, that's fine, but she has resources.
Yeah,
a lot of
that's the state's position as well, Judge. If she can marshal the resources to make the bond, the state's position is she can marshal the resources to pay for an attorney.
Yeah, I'm going to order that ultimately because she has resources and the people are going to pay. You get entitled to be paid because you're a fine lawyer and you do a good job. But the people are not stuck with the tab when the defendants have the ability to get resources. And as far as her other situation that you were talking about, okay, she's imperfect.
Mm-hmm.
Big deal. We all are. Each of us here have issues of imperfection, and some people's phones go off in the middle of the when they shouldn't. They.
No, you're right.
But welcome to planet Earth. But you just deal with the imperfections and do the best you can and make the best choices you can. And that's what we do. I wish I didn't make a mistake today. And we all make mistakes. And some of us and all of us have inabilities, whether it's I've got to wear contact lens. I don't have perfect eyesight. Everybody is born with Achilles heels.
Right.
And deal with them.
Right.
And we all deal with them and we do the best we can with what we have to work with, because our Creator gave us enough to work with to get the job done. And it's a test we all go through in making decisions and achievements through our life, in spite of the fact we're imperfect. You're in that boat. There is no reason. I've looked at this. There's no reason why you should be making bad choices. Fix it. If you make a bad choice, fix it somehow. Fix it and don't do that again. That's, and I'm sure that you have children.
Yes, sir.
I bet you told them that.
Yes.
Or yeah. Don't do that again. And then that's what a form of discipline as a parent to a child, because they go, okay, now I know what the right thing to do. We learn, and we learn through our whole life. Even adults make mistakes, older adults, and when we make a mistake, we fix it as soon as possible and correct it and do better. Don't do it again. But that's what probation is all about. And we're very excited about the performance that the probation has, because I want 100%. We're at 93. We have a 93% success rate on probation. The national average is 75. What does that say? These people are doing their job. They're great in doing their job. I had to tell a bunch of folks about it last night, and about how good and proud this county is with our probation office, because that's 13 out of 14 people do great. 13 out of 14. There's no reason you shouldn't be 13 out of 14. Except we're all held to the choices we make. You make a bad choice, you can be punished for it. You make a good choice, you're rewarded. It's simple. And here, we put you on probation a while back, and it's alleged that you're doing similar things. I don't know why that's happening. It needs to get fixed one way or the other. But your choices here were not well made according to these allegations.
Right.
And why you made poor choices, knowing that it has consequences to it, is what we're trying to get to the bottom of. Because I don't like failure. I wish it was 100%. I really do.
Right, and Judge, and that was another reason why I had CPS here, is that I anticipated, and my understanding from talking with CPS, that the state of Texas, by way of CPS, was going to advocate for her to continue to be on supervision. And the reason why is how well she did in her service plan with her kids. She's actively involved in the kids, and that's why
I hadn't heard anything. You know,
she's here.
I'm not
hearing this.
I'm not prepared to go forward with the hearing, Judge.
Yeah,
I'm just saying what I anticipated that she would have said.
Okay,
if we'd have
but all that's, I'm anxious to hear it, but she's on probation for harassment of a public servant. She is charged now with assault on a public servant.
Yes, sir.
Oh, that's good luck on convince me about that. I don't know what it is, but that's kind of odd. And those allegations are disturbing when if she's charged with similar conduct for which she was charged with before, for which she was disciplined for before, and for which she stated under oath that she would not do again. So that's going to be interesting. But hey, she's presumed innocent. I wrote that article. I'm pretty proud of that. But all of that being said, let's move on. Number one, again, she has access to monies. Those are going to go toward the payment of the people's servant that Mr. Adams is in representing you. If you're able to pay $125,000 of a bond, you're certainly going to be able to pay your public defender here, and that's going to be ordered. He gives us a bill at the end. When do we have a hearing?
Same date, if you don't mind, 3 weeks out, because I got that other guy. You
Good for everybody?
Yes.
Done.
Same date.
That's it. Thank you.
Thank you. Thank you, Richard. Hey, yes, I need you to have those day, so make sure.
Okay, here's you got it. So that's fine. All right. Desmond.
I talked to the state on that, and I think we worked that one out.
I need to talk to you some more. Can we pass on that one, Bush, just to make sure we're.
You want me to talk to?
Details.
That's fine.
I'll talk with it too. Y'all are talking. Y'all doing a lot of talking. Okay. Well, let me know on.
And Bennett is ready.
I'm looking at 2 cases on him, right?
Yes, sir.
Okay.
And Bennett is ready to go. We sent that to you.
I'm sorry?
Bennett was sent.
Okay, Bennett, come on up. That's Philip. Does he need to sign?
He's already signed.
Okay.
And he signed, Judge, and Ms. Simon sent it back to me, and I'll send it back to you.
Oh, that's what we call signing back. I like that. We now call cause number 24 CR 303, the state of Texas versus Philip Bennett. Is it Bennett or Bennett? Bennett. And you were here with Mr. Adams, your attorney, and the state's attorney.
Yes, sir.
What we have here is a motion to revoke probation. Is this the one filed on October 30 of last year?
Yes, sir.
Is that right? Yeah, that's locked. Everybody, is that right? He says yes. Was that right, Langston?
Yes, sir.
And say
yes, you
okay, good.
right here.
All right. I didn't know if there was another one coming through the pike or anything.
No, sir.
All right, in 24 CR 303, the state of Texas versus Philip Lawrence Bennett. Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this motion to revoke probation hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary, Mr. Adams?
Yes, sir.
In summary, this motion, which was filed October 30th of 2025, in summary, it states that on August 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for the 3rd-degree felony of deadly conduct by discharging a firearm. Is all of that true and correct, sir?
Yes, sir.
Allegation 1 states you committed the offense of driving while intoxicated, I guess operating a motor vehicle while intoxicated, a DWI.
Yes, sir.
On or about October 4th, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state. Is that allegation true or correct, sir?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes, Your Honor.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations, that's enough to grant a motion to revoke probation? Your probation can now be revoked. You can be found guilty and you can be sentenced to no less than 2 nor more than 10 years confinement in prison under this 3rd-degree felony. Knowing that, do you insist on pleading true to that?
Yes, Your Honor.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let's see, I'm looking at number 2 is failed to never become intoxicated. Do we really need that one? We've got the DWI. 1.
State's willing to abandon that, Your Honor.
3, failing to provide verification performing community service hours.
I'd like to leave that one in, please, Your Honor.
All right. Number 3 states you failed to provide verification of performing community service hours. And according to the administrative hearing filed by the probation office to support the filing of this motion, it states that you were assigned 600 community service hours. You completed 276 and have 324 remaining. Let me ask on probation. Was he doing okay on community service hours? He didn't complete them, but he was only on probation for a year.
Yeah, he was always almost at his halfway mark, Your Honor. Okay.
Well, okay, he was at his halfway mark on what?
Community service hours.
Okay, and he was on probation for 10 years, but he had only been on probation for a year, right?
That's right.
So he was about 10% of his probation time, but he had served half, he had covered half of his, that's pretty good, isn't it?
Yes, Your Honor.
Okay, I'm not going to punish him for that. He sounds like he was trying. We're going to be okay on that one. Can we abandon that?
Judge, if the court's inclined to find it not true, then I don't necessarily want to abandon it.
But where was he on? I mean, was he didn't complete it, but was he caught up?
He was almost caught up, yes, sir.
Well, I'm not going to punish it.
But if the court's inclined to find it not true, then that's fine, Judge.
All right. Number 4.
We'd like to keep number 4 and abandon number 5 with regard to the fees, Judge.
4 states you were at a location other than your residence at approximately, it says 23:49. That's military time. I presume that's 11:49 p.m. on or about October 4th, 2025, in violation of condition 18 of your probation order and 18 of your probation order states that you must be inside your home every day between 10 p.m. and 6 a.m. except for employment purposes. So that was about 2 hours outside your curfew. Is that true?
Yes, sir.
Are you pleading true to that one? That violation true because it is true as it is alleged?
Yes, Your Honor.
And I've already told you that a knowingly and voluntarily made plea of true to one or more violations, that would be enough to grant a motion to revoke probation, and your probation could be revoked. Do you understand?
Yes, sir.
No. And we're abandoning 5.
Yeah, Your Honor, with regard to the fees.
Yes.
The state has a brief argument.
We've got a second case.
We get to argue.
We've got a second case to deal with too.
I think they've got the same mirror allegations, Judge.
Mm-hmm.
Well, we got to pick them up.
Okay.
So 24 CR 304 is called the State of Texas versus Philip Lawrence Bennett, who is the defendant. And in this case, there's a motion to revoke probation filed as well as of October 30th of 2025. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
All right. And again, you're still under oath in this hearing, so remember that. All right. In summary, this motion to revoke unadjudicated probation states that on August 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation, as well as in the previous case for the 304 case of deadly conduct discharging a firearm, a third-degree felony. Is that true?
Yes, sir.
And
State abandons allegation number 2.
allegations 1 and 4 are the same as what you have pleaded true to in the previous case, committing the offense of driving while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and 4 at a location other than your residence at approximately 11:49 p.m. on or about October 4th, 2023. And those are violations of conditions 1 and 18, respectively, of your deferred or unadjudicated probation order. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those?
Yes, sir.
Voluntarily and because they are true as they are alleged?
Yes, sir.
And again, you are understanding that a true and correct violation of one or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced up to the full range of punishment. In this case, it's the same as the previous case in the motion to revoke probation. You were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Knowing all of that, do you insist on pleading true to allegations 1 and 4 in this cause number 24 CR 304 in this motion to revoke probation, as well as the previous one?
Yes, sir.
I find you are pleading true, voluntarily, knowingly, intelligently, and there is enough to grant these motion to revoke probation, enough evidence by a preponderance of the evidence or greater to support the motions to revoke probation. What are we going to do?
Judge, it's a cap of 5, and I got 2 witnesses I want to call.
And go ahead.
All right, I want to call a probation officer as the first witness. All right. All right.
Hold on. And raise your right hand, sir. Do you probation? But I like your vigor in raising your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? So lower your hand and go ahead.
Please state your full name for the record. Jesus Ruiz. And Mr. Ruiz, you were a probation officer in this case?
No.
Okay, who are you covering for?
Joseph Chandler.
All right, so you're covering for Mr. Chandler. That's fair. That's no problem.
So hold on. Are you familiar, though, with these files to be able to speak intelligently about what's in them?
Somewhat familiar, yes.
All right.
So basically what Judge said, you had a chance to review all of the notes of Mr. Champ and everything that he's done in this case?
Yes.
All right. And in doing so and reviewing Mr. Champ's notes, you understand that my client was placed on probation on the 27th day of, he was placed on probation specifically. This order was entered on 10/30 of 2025. That's the date that I see this file stamp. All right. All right. And let's deal with one of the allegations that was abandoned. And I think that that's positive for my client. You understand the judge pointed out that in terms of his community service, he's placed on probation for 10 years, right?
Mm-hmm. I want to be clear. The state didn't abandon that allegation.
Yes, you did.
No, I did not abandon the allegation about the community service. I welcome the court to find it not true if he was so inclined, but I didn't abandon.
Okay, well, at the bottom line is that would you, in terms of failure to provide verification of community service office, you do know that he's done over 50% of his community service?
Not 50%.
How much has he done?
276 hours.
Out of how many?
600. 50% will be 300 hours.
Okay, so he's pretty close.
Pretty close.
So as it relates to providing verification, you do know that he did do the 200 and what?
76.
And do you consider that doing pretty well?
It's pretty well.
That's pretty well. And is that better than most people who's on probation?
I'm not sure.
What are people who you supervise?
They tend to meet the halfway mark.
Okay.
And 93% are successful.
All right. The next point that I want to make to you is that in addition to doing this community service on his arrears, I noticed that these arrears are just $308. Is that right?
Yes.
Right. So he has been making payments while he's been on probation. Is it right?
Has been making some payments. That's it.
Well, not just some. I mean, at least according to what I got here, total credit 1,112 is what I read right here for the total credit as payments.
Yes.
Right. So he's not just making some payments. He made at least 1,112. I mean, so he's making payments, right?
Yes.
And I see that he's periodically making $60 payments, $155, $115, $105, $85. So he's making regular payments.
Yes.
Right. And that only left him with arrears of 308, right?
Yes.
Right. And in doing these cases, I've seen people that's $1,000 in arrears, right?
Yes.
So as another positive about my client, he's making payments and he's also ahead of the game in his community service. That's a positive, right?
I don't know about ahead of the game, but he's on his way. Yes.
Okay. Also, as it relates to the nature of the offense that the state is going on for this October the 4th, you did get a chance to look at Mr. Champ's notes and administrative hearings. In terms of this DWI, this is not a DWI where we got an accident, somebody's injured, a DWI where somebody is a danger to the road. This is one where he is in a parking lot parked and the underlying, and you can look at it if you don't, just to refresh your under findings. They had an administrative hearing and he's basically, have you seen this?
Yes.
Yeah, he's basically in a parking lot parked, right?
Mm-hmm.
So he's not driving a car at that time, is that right?
No.
Right. And so in terms of the seriousness of this particular offense, this isn't a DWI where you got a wreck, somebody injured, he's on the road, he's in the parking lot sleeping. Is that right?
Yes.
Now, the judge has mentioned about the success rate of the probation department in terms of programs that you can provide for him that he's admitted to on the driving while application on October the 4th. What programs does this probation office provide for people who have alcohol problems? Do you have any programs?
We have substance abuse assessments that we provide. We do have programs, yes, sir.
And at the time of this offense, was he getting any of those substance abuse treatment?
I am not sure.
Okay. And if he's continued on probation by our judge today, could the judge order him to take the substance abuse treatment while keeping him on probation?
That's his decision.
Could he do so? And the answer would be yes, he could, right? All right. Now, how do you feel about that substance abuse treatment program? Do you think it's a pretty good program?
It is a pretty good program.
How well is it? How would you describe it?
With my clients, they've had pretty good success.
All right. So do you have any reason to believe that if he's continued on supervision and he's put into this program that he would not be successful?
I'm not sure.
All right. But you
don't know the client well enough.
I got you.
Make that decision.
But in going through the notes of Mr. Champ, you don't see nothing that would say he wouldn't be successful, would you?
No.
All right. So in addition to the programs that you provide in your department, which is the substance abuse, how about in the community as a whole, Jefferson County? Do we have programs here to help people with alcohol, like AA, right? So not in addition to the programs that he would have access to through your department, which is in the community as a whole, we would also have access to those programs, right?
Yes.
So if the judge with this 5-year cap offer continues him on supervision, he could be in those programs and not be a danger to anybody in the community. Is that right?
I don't know about that. He could be in the program and still be a danger.
Well, you could be a danger to somebody today.
That's argumentative.
No, well,
State objects. That's argumentative.
Sustained.
Well, at the end of the day, anyone can be a danger at any particular time. Do you understand that?
Yes.
All right. So in his particular case, if he has the program that you just bragged about, if he has the access in the community and he's doing what he's supposed to do, he can probably continue to be on probation and be successful. Do you understand that?
Yes.
All right. And the probation department can meet all of his needs that need to be met. Is that right?
Yeah.
By continuing him on supervision. All right. My last question for you, and here's where I'll stop. I know you said that you were not the supervising officer, but in reviewing Mr. Champ's notes, from reading his notes, what are the positive things you can say about my client from your reading of all of his notes?
That he was somewhat compliant with his probation. He was going to office visits. Seems to be pretty good on this community service, and he was meeting his payments.
Okay. And did Mr. Champ express any feelings to you about this particular case? So when you covered for him, you basically took the file, but you didn't talk to him about as to what Mr. Champ's recommendations were, right?
No.
All right. So you're not prepared to give a recommendation today. That's more from Mr. Champ.
Well, he's retired. So.
Well, he's retired. Well, he can't now, but I'm saying he's not here to give a recommendation because he's the main one, right? And what you said that you can't do it because you're not the one who supervised. All right, pass the witness. Thank you for your time.
As I may, Your Honor, I'd like to direct your attention to the administrative hearing and the report or the document from that hearing dated October the 6th of 2025, particularly the findings. And if you need to, just take a quick look at it to refresh your memory of that. Well, recollection. Oh, just tell me when you're ready.
All right.
All right. Particularly with regard to these highlighted portions of the findings, when the officer or officers encountered the defendant with regard to the DWI arrest, where was he located?
He was in the middle of the parking lot.
And where?
At Taco Bell.
And did other vehicles have to go around him?
Yes.
And it was indicated that when law enforcement made contact with the defendant, what state or condition was he in?
He had a thick saliva running out the side of his mouth.
And eventually, the officers, how did they get the defendant to awaken or respond?
They had to be on the driver's side of the vehicle.
Okay. That's all. I'll pass the witness.
So basically, in what you said, I mean, people don't speed in parking lots, right? I mean, you shouldn't be, you shouldn't be. All right. So in terms of what he's in the middle of a parking lot and the saliva that comes out of mouth, I mean, the common term for that is drooling. I mean, that's associated with sleeping. You understand that, right? And at the end of the day, he's parked in a parking lot sleeping, and in that parking lot in Taco Bell, people drove around so they can get into the line to order their food. All right. So for purposes of continuing him on probation and how this question is relevant for the judge and continuing him on probation, out of all the kinds of DWIs you can have, this is not the most serious one. You don't have him drunk and killing somebody, drunk and getting into a wreck, drunk and hurting himself, drunk or hurting somebody else. He's sleeping in a parking lot. Is that right? Yes. Right. So, and that would be one of the arguments and basis for continuing on probation as it relates to the seriousness of the offense. Pass the witness and
just one follow-up question, Judge. Based on your experience, your life experience, how do you surmise that this defendant got to that parking lot there at Taco Bell?
The objection speculate his life experience is irrelevant to the question. It's told whatever his life experience is not a relevant question for this case. His life experience is not material to this case.
Your Honor, the court can draw an inference. I'll move on.
Go ahead.
That's all I got, Judge. I got another witness. That's it.
All right. Let me ask a question here. I'm looking at all the papers. The agreed punishment recommendation here, a cap of 5 years.
Made by the previous prosecutor, Judge.
It says the sentence will run concurrently with the DWI. What DWI are we talking about?
The underlying offense.
I think it's in Judge Holmes, if I'm not mistaken. And he's going to handle that too and try to dispose of everything.
That's the underlying offense, the Taco Bell incident we're talking about.
Okay.
I believe
So
that's
there's not an agreement that this, each of these would run concurrently, each of these motions.
They can run together.
That's not what this says. It says will not exceed a cap. Look what it says.
No, I believe
See, it doesn't, it just says the DWI. It doesn't say concurrently with the other.
I can add that. It was.
Is that the plan?
Yeah, that was the plan.
While I didn't negotiate it, Judge, I can understand that would be the intent of the parties.
Right.
Okay.
Right.
You want me to add that?
Yes, sir.
No objection, Judge.
Okay. This is 303. So what I'll do is we'll run concurrently with DWI and 24 CR 304. Good.
And that's
what we'll do on the other plea agreement. It will run concurrent. The 304 case will run concurrently with 303 on the other one. We'll make a change on the other one as well. Langston, okay?
Yes, sir.
Go ahead. Y'all go.
It will both line. This is Van Look.
Come on.
I don't have any more questions for you.
No, she's going to come up. He's going to have to see the bailiff. Well, the bailiff makes the decision when they're in custody. He can sit right there though. He'll be present, or he can sit in the witness chair.
Well,
I don't care.
I don't have a plan. That's something new. I mean,
we don't do that. It's up to the bailiff's decision.
I don't know how that affects any substantive right of the judge.
It doesn't. He's present.
Yes.
He's present. That's what's important. He's present. They don't have to stand next to each other for the law to apply. Go ahead. Call your witness. What's your name?
Can you state your full name for the record?
All right. Raise your right hand, man. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Correct? Okay. Lower your hand. Thank you. Go ahead.
All right. Mr. Bennett, my client, how do you know him? All right. And were you with him when he got first put on probation? Were you helping him?
Yes, sir.
All right. And do you understand that today is a motion to revoke his probation and the judge could put him in prison up to 5 years and keep him on probation? Do you understand that? And as his grandmother, you're here today to talk about how well he was doing while he was on probation, right? Could you tell us some of the good stuff that he was doing while he was on probation?
Whenever I believe in this stuff, I can't.
Well, speak up, what you need.
Whenever I needed him to help me around the house, he was always there present. And he helped me pretty well. And he always was obedient for me.
Yes, ma'am. So how did he help you? Do you depend on him?
Well, yeah, we would depend on him, like when I needed lights changed on the flood lights. He was there. He kept me well.
So basically, the heart of why you're here is you're here to testify to why would you want the court to continue him on supervision, right? And not send him to prison.
Yes.
So can you tell the judge in your own words, why would you ask the judge to keep him on probation?
Because he's not really there, you know. He's so deep. We have a kind heart. And he likes to work.
And if he's on probation,
take care of the son, his 3-year-old son.
Now, you heard the probation officer talk about what kind of great substance abuse program that they have. If the judge keeps him on probation, would you help him with transportation and getting the substance abuse treatment that the probation officer just talked about?
I don't drive no more, but I can get someone to bring him.
You better get somebody to bring him. And who's the lady in the blue?
That's his mom.
That's his mother. So his mother has transportation, right? And the mother still got you to court today, right? And do you know whether or not she'll be willing to get him transported to where he needs to go on probation?
Yes.
And apparently he's been doing pretty good because he's been paying his fees. He's been reporting, at least from what they're saying. He's doing well with his community service, right? So all of those are positives and would be indicators that if he is continued on supervision, he's going to do well. There's no reason, right? Right. And another argument, and I'm asking you a question. Would you agree with me? Did you hear the court, mention with the other lady about, having the taxpayers' money and spending taxpayers' dollars? Wouldn't it be better to continue him on probation with the support of his family and the support that he has around him than have our tax dollars locking him up in prison where he's not going to get that support, right? Okay. And he's not, in your opinion, do you believe that he's going to be a danger to himself or anybody else, or he's not going to be a danger? And even in this underlying case, he was in the car basically sleeping, right? Mm-hmm. And with those other resources, AA and all the other resources that Jefferson County has, would you and the mom make sure that he gets that treatment and those things? Yes. All right. So at the end of the day, and here's where I stop. Do you want your grandson to be continued on supervision? To continue to be on probation, that's what I mean. Yes. That's all I got. Thank you for your time.
I have no questions for this witness, Judge.
All right, anything else?
I think that's it.
From anybody?
Anybody?
Okay. All right. She can be seated and the defendant needs to come up. Are you calling somebody else?
Just that'd be 30 seconds. Come on, man.
I'm just waiting.
And I'm just gonna ask her one question. What would she like to tell you? And that's his mom. I'm just asking one question, and you can tell the judge whatever you like.
Well, Judge, I would have kind of objected to narrative.
Hold on. Identify.
All right, would you state your name?
Yes, my name is Stephanie Bennett.
And how are you related?
I'm his mother.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. It depends on where it was. Let him ask if you want to make an objection.
Well, Judge, in response to him, a narrative, the response is not necessarily objection.
You just ask the question and we'll play from there.
All right. What did you want to tell the court?
Yes, sir. I'd like to let you know that I do have a job. Make a lot of money.
I'm talking about him.
Money. Yes, sir.
Yeah.
And
how's that relate to him?
Yes, sir. And it's my son. And I have a little money I give to him. He wanted to be a man, so he cut grass to pay his fees. So when he was paying $80, he wasn't just sitting in the house. It was very hard for him to get a job as a felon.
Yeah.
So he did cut grass. He did what he could to pay. And when he started his job, he had to do training. So he couldn't feel back when they did on his community service, trying to work and provide for his son. He has a son with special needs right now. Just found out.
I'm sorry, he was special needs.
He has a son with the special needs. He's autistic. And
wait. Where does that son live?
That son lives with me and his mother. While the mother worked, we have the baby.
No. Okay. When he wasn't in jail, where was he?
He was
and the child.
He was taking care of his son while the mother worked. And between his work, yes, sir.
Okay.
And he also took care of my mother.
Hold on. Well, let me ask you, not to interrupt you, but who's taking care of that child at midnight when he's drunk and intoxicated and inebriated at a location and completely unconscious? Who's supposed to be taking care of this child that we're so concerned about, that he's supposed to be loving and caring for, like me as a parent, because I've got 2 children.
The mother. He had just got.
Well, where's the mother?
The mother, she's
at the time.
They don't live.
She was at work. Wait a second. She's intoxicated and wiped out at the drive-through, and the mother is working. What's the child doing by itself?
No, the mother wasn't working. He had gotten off.
You said she was.
The mother had the baby. The mother was at home. He had gotten off from work. He was at work that night. And he had gotten.
Why wasn't he at home taking it? Takes. I'm a parent. It takes 2 to run the household. Why isn't he at home at midnight when he's supposed to be just as a good parent? But not only that, he's ordered to be at home. What is it, at 8 p.m.? He's ordered to be. He was 4 hours late. He's intoxicated and unconscious in the public while the family is at home. That's not good parenting, is it?
They don't live together, sir. He lives with me.
Okay. All right. Why is he somewhere else other than at his home where he's supposed to be as the court ordered? I know you can't. It's not fair for you. I understand.
He takes good care of my mother. He takes her to the doctor.
He can't do it when he's intoxicated and unconscious at midnight out in the public, can he? No. You got responsibilities, sir. My God. Those are special. Our Creator gives us our children, and you're supposed to take care of the gifts that are being given to you. And you're unconscious on my watch on probation when you know better. Reminding you, you're on probation not for just something, not from just spitting on the sidewalk. You shot at a car, and shot at buildings. I mean, all kinds of trouble was happening there. Many could have died. So you have to be, when we placed you on probation, which was a close call on a charge of what's called deadly conduct, that's a very serious crime. I stuck my neck out and allowed this probation. And I was hoping you would, like I hope all of them, do well on probation. 13 out of 14 are successful. I didn't want you to fail. Nobody wants you to fail, but these are your choices. Not everybody wants you to do well, but you've got to do the lifting. You've got to do the heavy lifting like each of us do each day. We're responsible for our actions. And you pay when you are irresponsible. But I'm telling you, this is irresponsible behavior at midnight when you're supposed to be at home, when you're on probation for 2 deadly conducts. You're supposed to be taking care of family. But for some reason, you're out, wiped out, intoxicated in the middle of the parking lot and at midnight. And you're supposed to be at home, sober. I'm railed on enough.
Well, on that issue, was this something out of the ordinary, or this is something that happens all the time?
Out of the ordinary.
Right. So on the point of him being in the parking lot on that particular day, are you saying that that's something that's just out of his character?
Completely out of his character.
And what would substantiate your position is that let's look at what he was doing on probation. He's paying his money. He's reporting. He's ahead of the game on community service, right?
Yes.
He's being complimented by the judge on what he's doing with his community service, right?
Yes, sir.
So at the end of the day, if we compare his actions while on probation to this one particular day, then this one particular day is out of the ordinary. Is that right?
Yes.
And would you say that the chances of another day like that happening again is not really good? Is that right?
Not really good. He wouldn't do it.
Right. And probation department just talked about their programs and how good the programs are. And if the judge puts him on those programs, you got the transportation. I think that's why you told the judge that you got the transportation. You will get him to the places that he needs to go, considering that this was an out of the ordinary situation.
Yes, sir.
Is that right?
Yes, sir.
Thank you for your time.
I have no questions for this witness, Judge.
And you let me just correct for the record on the math part. This was his second bad day. His first bad day, we put him on probation for.
You come this way, my man. I got you. I'm not arguing with you.
You can only do the best you can. All right.
Did you want to hear from him?
It's up to y'all.
Did you want to say? Yes, sir. All right. One question for you. You know that judge can put you in jail for up to 5 years.
Have I signed credit?
Put it up there.
Thank you.
The judge can put you in jail up to 5 years based upon the plea deal that we got with the state of Texas, or he can continue you on supervision. Speak on your own behalf now and tell the judge why we're asking to be continued on probation. You tell him.
Yes, sir. I really just was trying to make it back home to make sure I could take care of my grandma and my child as well. I mean, I was doing everything I was supposed to do. I was taking care of all of my fees and doing my community service, but like my mom wanted to previously said, I just wound up starting the job and I started putting more time into it. And I also have messages between me and my manager. Me and my manager would always talk. I was just putting a lot of time just trying to learn stuff, but I was going to become a manager. So I'd be making more money to provide for my family. and I wound up going through a little depression. And I also got the records from Spindle Talk. I could get those two as well. I just wound up going through a depression dealing with my first case. So.
What do you mean? Depression for your first case? I mean, you intentionally committed those acts. What are you mad at yourself? You intentionally committed those acts. That's what you pleaded guilty to. What are you in depression for? You acted with intent to do that. So it's not like it was an accident or you were forced to by someone without your free will.
Yes, sir.
Don't be blaming something when it's your intent. You've got to stand up like a man, and actually that's what you did when you accepted responsibility the first time.
Yes, sir.
Because this was serious.
And you heard about from the probation officer when he testified about programs that are available to you. Did you hear his testimony, right?
Yes, sir.
And I asked him, "Think his program was pretty good?" He said, "Yes, it is."
Yes, sir.
That came from them, right? So if they have a pretty good program and he says that it's a pretty good program, your mama's saying that she's going to do the transportation to get you there. The question I got for you is, if the judge keeps you on probation, will you do the program?
Yes, sir.
And will you be there and listen attentively and do what you need to do?
Yes, sir.
All right. So are you asking the court to continue you on supervision based upon what the court has heard from the probation officer, yourself, your mother, as well as your grandmother?
Yes, sir.
All right. And this time, if you got this one shot, you're not going to let it up and down, are you?
No, sir.
All right. Thank you for your time.
I have no question for this defendant.
Don't go anywhere. Anything else?
That's it, Judge. I just would ask the court to continue him on supervision, and I'm not going to rehash everything that you've already heard.
I'm sorry, please.
I'm not going to rehash everything that you've already heard. It's just listening to the mom, the grandmother. I really believe that they're sincere from their heart.
Hey, let me ask something before we finish up here on evidence in this case. I'm looking at.
Yes, sir.
This report on this event at 11:30, almost midnight here on October 4th. And it states, I requested Philip's blood, according to the policeman. Requested his blood. He consented. He also signed a DIC 24. I transported him to the county jail, checked the blood draw, ensured it was not tampered. It was not tampered. Draw was made at a little after midnight, about 1 o'clock, and he was released. I placed the blood evidence in the blood evidence fridge. There's nothing in here that talks about what the.
We got the test back.
I don't have anything about the result.
If there's no objection from Mr. Adams, Judge, I tender it to the court.
It came back.
I tender to the court the lab report indicating a 0.197 BAC from that evening.
Okay. Well, that's 2.5 times the legal limit of ethanol. So you were 2.5 times the legal limit at midnight when your family was at home and you should have been at home, right?
Yes.
Okay, give it your best shot.
Judge, like I said, you heard all of the testimony. I do believe, and I'm not going to rehash everything that you've heard, but I will give my commentary on that. I do believe that the grandmother, I do believe his mother is absolutely sincere, and they appear to be.
I'm sure she is.
And I don't know them personally, but just from my judgment of character, they really truly love their grandson, and I really believe that they're going to be there to help him do well on probation.
But they were there before.
Right, and as they testified, that was an out of ordinary situation, with the probation saying that the treatment program, the substance treatment program, is so good. I don't have any doubt that they're going to make sure he gets there, and I don't have any doubt that he's going to actually go there and get the treatment that he needs. And I think that Judge, if just from what I can tell about him, and that's just my position and argument, he doesn't appear to be one of those type of guys that needs to be incarcerated in prison, that's going to be a danger, that's going to be acting a fool. And I understand what's the underlying offense. I get y'all.
What about that?
No, I hate that.
Was
that
have you ever done such a thing? I haven't. I wouldn't even thought about shooting at cars and buildings,
right,
at people where people can be shot and killed. Come on. That's
no.
He was, you represented him on the underlying case, right?
Yes, sir.
Yeah, you did a fabulous job on giving him a second chance in light of the potential catastrophe that could have occurred because there were numerous bullets shot. Yeah, that was a remarkable defense of getting him deferred or unadjudicated probation. And that's why, and you made promises to me, I'm going to follow these rules. And I stuck my neck out and gave you that chance.
And in terms of following those rules, Judge, I would ask to give him some consideration just on what the probation department said. In following those rules, he reported, he's doing that community service.
He's not getting punished for what he did do.
No.
Properly.
But
he's going to get punished for what he failed to do as required.
Right. But I was asked that the court would take that in consideration for mitigation purposes, because those were the things that he did well. And your probation department brought those things out. And the point that I'm making, Judge, is that I totally feel you on the underlying offense. But just look at it. I mean, he doesn't seem to me as that type of guy that
he's been in jail.
Well, they
don't let him have handguns in jail, and they don't let him drink.
No.
I mean, he's. But that's the problem is when he's in the free world, we have a problem keeping him from making mistakes and not following the rules. That's where you're not getting punished for good behavior. You're punished for failing to conform to what you were required to do, that you promised you would do. Follow all the rules.
I just think, Judge, if you give him this one shot, and I know you gave him the first shot, which was probation. If you just give him this second shot, let's say that the second shot, I don't believe you'll see him again. And I just get that impression just from the support that he has for the family. I mean, you just think about this, Judge, and here's why I be quiet. Think about all of the people who come in your court, right, who don't have that family support and background. He does have that support. And I think that grandmother, and you can look at her, she appears to be a wise lady, years of experience and wisdom. And I think when they have that heart-to-heart grandmother, grandson conversation, if you continue him, I think after that conversation, the chances of him coming back is not going to be good. And I think that conversation is going to take place.
Most people in this room who are defendants don't have that kind of familial support and role modeling at home. He does.
Yes, sir.
Shame on him for having that environment, knowing right from wrong, and still making the wrong choices. Not one wrong choice, choices. You had role modeling at home. That was good. You go against what they were representing. You acted contrary to what their role modeling and examples were. And reminding you what you tried to tell me a little while ago that I find disturbing is I've got family at home. You had a family at home at midnight when you were almost three times the legal limit of intoxication while you were on probation that forbid that kind of behavior. You should have been at home taking care of the family like you promised you would. And you were put in harm's way because you shot up the town that night and almost killed numerous people by shooting into cars and buildings. Next. What else?
That's all I got.
Yeah, I'll be brief because actually I had an outline of things I want to hit and I ticked them off as you mentioned them. The fact that probation was essentially a gift, you've mentioned that Mr. Adams was admirable in his advocacy in securing this probation for this defendant. I ticked off the fact that you mentioned that your order was a promise that this defendant made. What good is an order if you don't enforce that order, Judge, when it's violated? It's not a suggestion. It's not an invitation. It's not a pretty please. It's an order from the court. This defendant, he violated that order. I ticked off the fact that you mentioned that it's his decisions. It's his decisions that put him before this court. There should be consequences for those decisions. And lastly, Judge, I also ticked off the fact that I was going to remind the court of the underlying facts surrounding the underlying offense and the fact that he's in a shootout with some other fellow and he's shooting at cars and buildings. And you mentioned that, so that makes my argument very brief, Your Honor. It is admirable that this defendant completed the community service hours he did. It's admirable that he was paying the fees that he paid, but nevertheless, there needs to be accountability, Judge, for violating the court's order. Judge, I go back to my time in the military when there was a phrase that was used called turning sharp corners. For this defendant to be given the gift that you gave him by putting him on probation, he should have known that the corners he turned, he needed to turn sharp corners. And he was cutting corners that night in that Taco Bell parking lot when he was intoxicated, Judge. And the court knows in its common sense that for him to get to that Taco Bell parking lot, he had to drive there, Judge. And in driving there 3 times the legal limit, he endangered the public like he endangered them during the shooting incident, Judge. 5 years is what I'm asking, Judge. I'm asking you to revoke this defendant and assess his punishment at 5 years, which is essentially on the low end or the mid-range of the punishment range in this case, Judge. Mr. Adams made the comment that give him one shot. Judge, when does one shot turn into a second chance, turn into a third chance, turn into a fourth chance? He's making a mockery of this court and this judge's order.
No,
it's his argument, Judge.
No.
Hold on. Let him.
How am I making a mockery of?
I didn't say you.
Hold on.
Oh.
Hey, one at a time. Break clean.
I didn't say he was.
Okay.
He gets a chance to be heard, and I'm gonna let you end. What else?
No, my point was the defendant was making a mockery of this of your order.
I thought
that's the way I understood.
Yeah, I thought he was saying I was. Okay, never mind. I take that back. I'm sorry. I apologize for interrupting.
I'm asking you to sentence this judge, sentence this defendant, revoke his probation, reform his judgment, Judge, send him to a prison for the decisions that he made that brought him before you today. And I'm asking you to assess 5 years in TDCJ, Judge.
All right. Anybody else? Anything?
Judge, I'm just asking, and I'm not going, when you heard the argument, it's not for him, for his mom and his grandmother, just to please continue.
I feel small. And you're right. I feel sorry for them. Why weren't they important to you at midnight when you were intoxicated on probation, when you had everything to lose? And they're taking, but you made a promise to me that you would take care of things. And I stuck my neck out on this because these are 2 crimes of serious violence, which could have resulted in multiple injuries or deaths. On each of these cases, in 24 CR 303 and 304, where the defendant was placed on probation, deferred or unadjudicated probation for 10 years for deadly conduct, discharge of firearm, a third-degree felony in each case. In this motion to revoke probation, I find that the defendant has pleaded true to allegations 1 and 4, committing the offense of operating a motor vehicle while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and being at a location other than his residence at midnight on or about October 4th, 2025. Those are both violations of terms and conditions of his probation. I find that his voluntary and knowingly plea of true are enough in each of these cases to support those findings and allegations by a preponderance of the evidence or greater. I find them to be true, and thus these motions to revoke unadjudicated probation in each of these cases are hereby granted. In each of these cases, the defendant pleaded guilty voluntarily, knowingly, intelligently to the crimes of deadly conduct and discharge of a firearm, a third-degree felony in each of these cases. The defendant was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea in each case from State's Exhibit 1 to find him guilty beyond a reasonable doubt. His deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt in each of these third-degree felonies And I am following this agreement. The agreement that was reached is whatever sentence shall not exceed a cap of 5 years. You being found guilty of these third-degree felonies, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years on each of these cases. These sentences shall run concurrently. Also, these judgments shall reflect affirmative findings that a deadly weapon, namely a firearm, was used in the commission of each of these crimes. Do you understand what has happened now, sir?
Yes.
Your probation is revoked and you are sentenced. And again, this court hates failure. I want to see success. I wish we had 100% rather than 93%. But you understood and appreciated the importance of the seriousness of this violent crime. We all stuck our neck out giving you a second chance. And it wasn't long, a year, and you are failing. And this was fixable. I think you're capable of doing the right thing and doing better. I'm disappointed because I had good ideas that you had fixed these mistakes and you were going to live better with better decisions. But once again, you have family and responsibilities at home at midnight. You're not supposed to be at midnight intoxicated, drunk in a vehicle, sitting around intoxicated while the family is at home and you're on probation. You have to pay a price. Fix this, get out and make a responsible, exemplary life, not only for yourself, but for the children who you are going to be role modeling. You have to set an example and you are able to be better. Do it. All right. That's my wish for you and your family. And again, these sentences shall run concurrently. Anything else?
That's it. Back on the stage, Judge.
Thank you, Judge.
Here. Yes. Oh. Next. Take their seat. Judge, thanks. Here's that. What are you doing on yours? On, let's see, let me call it, it's going to be. Okay, is it Joe Lewis?
Yes.
Not the famous Joe Lewis.
No, this is Joe.
Oh, it's that other famous Joe Lewis.
So the wrong reason.
Careful now, heavyweight champ, I've been 37-49.
Undefeated.
He's tired of that junk though, Judge.
All right, on a Sheikah Stewart, it looks like that has been reset. Ms. McNally.
Yes, it's just TC.
All right. And again, on Mr. Lewis, are those all signed, ready?
I'm signing it.
Okay.
I do need a
He
fingerprint.
needs to get fingerprinted, Mr. Lewis. while we are waiting, we have a Jermaine Reader.
Yes.
And what's our plan with Mr. Reader? Is there attorney present on this?
Yes, sir.
You know what? I don't have a file.
Right. No.
I have Joe Lewis's files. I have a reader.
This is the one we talked about.
Do we? Hold on. Oh, okay. All right.
I get that report, Joel. I'll forward it to you.
And once again, on Mr. Reader's case 22-39691, I think. Dr. Rapon evaluated the defendant, deemed him to be competent to stand trial. He will be on the trial docket Monday, and we will try that case Monday. That's our plan. Okay.
Thank you, Judge.
Thank you.
Wow.
All right. Joe Lewis? Everything being signed?
Yes, sir.
Right. Mr. Lewis, 3 cases, I think. Is he going to be pleading to all 3?
No, just one, 343 be dismissed.
Dismissed?
Yes, sir.
Okay, so 2 out of 3. He'll be pleading to, correct?
Yes, Your Honor.
Okay. We'll multitask here. Let me get all these in an order. We call 3 cases, 26 CR 60, 26 CR 343, and 26 CR 344, all styled the state of Texas versus Joseph L. Lewis. You were Mr. Lewis, and you were here with Ms. Coffin, your attorney, and the state's attorney. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, Your Honor.
And 343 is to be dismissed. Is that our plan?
Yes, Judge.
Okay. And that was a stage L felony of fraudulent use or possession of identifying information. And that will be dismissed as part of this agreement. He's got the other 2, 26 CR 60. Are we just proceeding on paragraph 1 on each case?
Yes,
There's a
yes, Judge.
another prior conviction alleged, an enhancement, but we are abandoning that.
The state will do so, Judge.
All right. In summary, Mr. Lewis, this indictment in 26 CR 60 alleges that on or about August 26, 2024 in Jefferson County, Texas, you knowingly and intentionally illegally possessed a controlled substance, namely phencyclidine, PCP, in an amount by weight of 4 grams or more, but less than 20 grams. Do you understand what you're charged with here, sir?
Yeah.
Yes. If convicted, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case. You would be pleading guilty, sentenced to 4 years in prison to run concurrently with the next case, 26 CR 344, harassment of a public servant. And again, a 3rd case will be dismissed, 26 CR 343. Is that your understanding of the plan here?
Right.
If I follow this agreement, you have no right of appeal. Do you understand?
Right.
How do you plead to this charge, sir? Guilty or not guilty? Guilty or not guilty?
Guilty.
Are you pleading guilty here voluntarily and because you are guilty? Put that one aside just for a moment and go to 344. And again, in this case, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 5th, 2025, in Jefferson County, Texas, you committed the third-degree felony of harassment of a public servant. Do you understand what you're charged with here? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case where you would be pleading guilty and sentenced to 4 years in prison to run concurrently with the preceding case you pleaded guilty to today. And again, that third case would be dismissed. Is that your understanding of the master plan?
Yeah.
If I follow this agreement, you have no right of appeal of your cases. Do you understand? How do you plead in each of these two cases? Again, 26 CR 60 and 26 CR 344. Guilty or not guilty?
Guilty.
You are pleading guilty voluntarily in each case and because you are guilty. Is that true, sir? I show you in each of these cases what's marked as State's Exhibit 1. Did you sign those documents? Understand them? Discuss them with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence in each case?
No objection.
Without objection, admit. These state that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You read them. You are guilty of the crime charged in any lesser included offenses in each case. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. States Exhibit 1. Part of the record for all purposes. Pre-sentence reports are waived in each of these cases?
Yes, sir.
Yes, Judge.
I will follow these agreements, if nothing further, and I will find Mr. Lewis in each of these two cases, 26 CR 60 and 26 CR 344. The illegal possession of a controlled substance, and 60, a second-degree felony, and the harassment of a public servant charge, a third-degree felony, in 344. In each of these cases, you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these two cases. I am following these agreements. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Confinement in each of these cases. Sentences shall run concurrently. And also, I have this third case, 26 CR 343, by agreement, that shall be dismissed. That state jail felony of fraudulent use of identifying information. And I will sign that dismissal here in a moment. Do you understand what has happened today, sir? Anything else, Dan?
Your Honor, I do have the discovery certification.
Oh, okay. I didn't get you anything. And we'll put this in the file. Thank you. Anything else? We never says. Okay, thank you.
May I be excused?
Best to your family.
Thank you, Your Honor. I would appreciate it. Thank you.
So.
There's no.
Okay, for
Oh.
You're good.
Ms. Coffin, you have a second here?
Sure.
Good morning. Court calls case Danny Noonan LLC versus Nicholas Cervella.
Good morning, Your Honor. David Fant.
The 14A District Court, County of Washtenaw, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning. Court calls case Danny Noonan LLC versus Nicholas Cervella.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Not checked in.
Cervella? No response. If you'd like to take a default, please raise your right hand.
I no response. I want to respond.
Hold on a second, sir. Sir, hold on. You didn't put your name in. What's your name?
Nicholas Cervella.
Okay, very good. All right. Then, Mr. Fantera, what is plaintiff's claim in this case, including court costs?
He has a balance, including court costs and July's rent, of $1,105.
All right. Mr. Cervella, how are you intending on getting that paid, sir?
No, I have my buddies. I'm at 915. I'm under $1,000 and I'm going to pay this by September.
Well, dude,
my man, I had problems with owing people money, and I don't want to be evicted, but I know that I can pay this by September.
Okay, you're going to have to try to work that out with the landlord because I can't get you through to September.
I know. Now I've dealt with bed bugs here. I've dealt with a lot of stuff.
Right, sir.
In my life right now.
Sir, are you going to have an attorney represent you in this matter?
No, I want to pay it all.
Okay. Then what I'm going to suggest you do is you either contact your landlord directly or contact Mr. Fantera's office. I'm going to adjourn this out. I have the 24th, correct?
Yes.
I'm going to adjourn it out 1 week to July 24th, 2026 at 12 noon. That is an in-person hearing, sir. So you'll have to show up at the courthouse and then we can figure out what we're going to do. All right?
No. I have a week to pay this?
Sir, you have a week to show up for another hearing.
I paid my bills. I let this woman borrow money from me, and I need a little more time.
Sir.
I need a little more time, sir.
Then what you're going to need to do, if you're going to work out a payment plan with the landlord, you're going to either need to contact your landlord or contact Mr. Fantera's office. As far as the court proceeding, I've set it for another hearing, and that hearing is next week at noon in person. All right. Thank you.
All right, thank you.
Thank you, Your Honor.
Ian Greenlee versus Ches Williams.
Good morning again, Your Honor. David Fantier on behalf of the plaintiff.
Not checked.
Ches Williams, they are not checked in. I'm almost afraid to ask you to raise your hand. Raise your hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Yeah, I wasn't quite sure how far we got that first time.
Yeah. Go ahead.
I'm David Fantier. I'm the attorney for Ian Greenlee, and such I'm familiar with the books and records they relate to this tenancy In this case, there's rent owing in the amount of $2,310, court costs of $175 for a total of $2,485. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. Mrs. Haverkamp versus Jada Wimberly. That matter is dismissed on plaintiff's motion without prejudice.
Thank you very much, Your Honor.
Thank you, sir. Augusta Woods versus Papagaye.
Good morning, Your Honor. Michael Burns, P 87855 on behalf of plaintiff.
All right.
There's a Alessandro guy.
Yes.
Yeah, I'm right here.
Okay, who are you?
Papa Alessandro. Yeah.
Got it. All right. What is plaintiff's claim, including court cost?
Thank you, Your Honor. This is a non-payment of rent case. We're showing rent due in the amount of $1,656.21. Cost in the amount of $195 for a total due and owing of $1,851.21.
All right. Sir, how are you intending on getting that paid?
Yeah, I'm gonna try to pay for it before the end of this month.
Okay.
Yeah.
So you're gonna try to get it all paid before the end of the month?
Right.
Okay. Do you have anything you can pay before next week?
Not yet, because I was waiting for my payment. I just got this job.
Okay. So here's what I'm gonna do. I'm going to adjourn this out 1 week, July 24th, 2026 at 12 noon. That's an in-person hearing. What I suggest you do is contact your landlord or their attorney's office to see if you can arrange some type of payment agreement, okay?
All right.
Thank you.
All right, thank you.
Augusta Woods versus Anthony Wilson.
Good morning again, Your Honor. Michael Burns, P 87855 on behalf of plaintiff.
Hello, Your Honor. Anthony Wilson.
All right. He's got his camera turned on, but something's wrong. Okay. All right. What is plaintiff's claim?
Thank you, Your Honor. We are seeking a non-payment possession judgment. Rent to retain is $1,671.46. We have cost in the amount of $195 for a total due and owing of $1,866.46.
All right. And Mr. Wilson?
Yes, Your Honor.
How are you intending on getting that paid?
Well, next week I'll be able to, before court, to get in $800 to $1,000, and we can go from there.
All right. You're going to get $800 to $1,000 before next Friday?
Yes, sir.
All right. So what I'm going to do is you get that paid to the landlord, then we can figure out where we're going to go. I will adjourn this out 1 week to July 24th, 2026 at 12 noon. That's an in-person hearing, so you'll have to come down to the courthouse unless everything's paid.
Okay. Thank you, Your Honor. Have a good day.
You do the same, sir.
Thank you.
And that's the last one for me, Your Honor. I appreciate your time.
Yes, sir. Take care. Arbor Woods versus Kymarie Smith.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff. And Your Honor, I think the second defendant, Terrence Smith.
Yes, and Terrence Smith.
Good morning, Your Honor. Terrence Smith.
Good morning. All right. What is plaintiff's claim?
With costs, Your Honor, $1,910.72.
All right. And Mr. Smith, how are you guys intending on getting that paid?
Oh, it was paid yesterday.
Oh, you paid it yesterday?
Oh, yes.
The full $1,910.72, Mr. Smith?
Yeah, I actually paid $19.72 because they said it was a little more due to paying by money order.
Got it. All right. Your Honor, if we could adjourn this one for 1 week, I'll verify, and I'm sure we'll have the dismissal submitted. Mr. Smith, was that paid via, you said via money order?
Oh, yeah.
Okay.
All right, Mr. Smith, I'm going to adjourn this out to July 24th, 2026 at 12 noon. What time? 2 p.m. If everything is paid, you don't need to come down to the courthouse. It'll be dismissed out. Okay, sir?
Okay, will I receive something saying dismiss out, just so I'm covered? I don't want to.
Your Honor, if Mr. Smith wants to give my office a call next week, I mean, I would say maybe wait till like Wednesday just to be safe. It gives us just more time to verify it, but I'm sure I'll have an answer today. So Mr. Smith, the paperwork that told you to appear today lists a Matthew Pallets out of Troy. It's a 248 number. If you call that number next week, I can verify whether we've gotten that confirmation from Arbor Woods.
Sound good?
Thank you.
All right. Thank you, sir. Have a great weekend.
You as well.
Coachville versus Eden Vasquez. Eden Vasquez, they are not here. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Pallets Law, on behalf of the plaintiff, there's rent to retain of $1,499.44. Costs are $175 for a total due of $1,674.44. And we'd ask for a default possession only judgment with right to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Northville Crossing versus Ashley Kuzma and Brendan Kuzma. Not checked in. Kuzma, not here. You may proceed.
Thank you, Your Honor. There is rent to retain of $7,369.47. Costs are $250 for a total due of $7,619.47. And we'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. Scio Farms versus Bridget Long. And I think she's here. Hello, Ms. Long.
Good morning, sir.
All right. What is plaintiff's claim?
Kevin Lutke.
All right, thank you, sir. Let me call your case.
Judge, that's my client.
Thank you, Mr. Lumberg. This is the state of Michigan versus Kevin Ludke, file 26-44567-FY-3. Mr. Ludke, my name is Judge Hesselink. I'm coming to you from the district court. I'm going to arraign you, which means I'm going to tell you what you're charged with, tell you what your rights are, and then we'll address the issue of bond. And your attorney, Mr. Blumberg, will participate in that process. Listen carefully while I read the complaint to you. It says that on or about April 15th of 2026, in the Chester Township of Otsego County, that you did commit in count one, the offense called carrying a concealed weapon. That reads that you did carry a dangerous weapon. That is a Ruger Max 9mm semi-automatic pistol concealed on or about your person, and whether concealed or otherwise in a vehicle operated or occupied by you, and that being a 2027 Subaru Crosstrek, contrary to the Michigan compiled laws. That is a felony offense, has a maximum penalty of 5 years and or a $2,500 fine plus mandatory forfeiture of the weapon. Do you understand the name of count one?
Yes, Your Honor.
You understand the maximum possible penalty for count one?
Yes, Your Honor.
And you are also charged with count two, which is called possession of a firearm in a motor vehicle or a boat. It reads that you did transport or have in your possession a firearm in or upon a vehicle, and the firearm was not enclosed in the case, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 90 days and or a $50 to a $500 fine, plus the costs of prosecution. Do you understand the name of count two?
Yes, Your Honor.
Do you understand the maximum possible penalty of count two?
Yes, Your Honor.
As to each of these charges, you have the following rights. You have the right to be tried before a judge or a jury. You have the right to have an attorney represent you, such as Mr. Blumberg, and you have the right to plead guilty, not guilty, or to stand mute. If you wish to have a trial, you'd also have the following trial rights. That is to seek, hear, and question all the witnesses against you, to present your own witnesses and evidence, to get a subpoena from the court, to require your witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error, but if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just read to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Mr. Blumberg, how does your client wish to plead today?
My client will be pleading not guilty to both charges, Your Honor. We have had some preliminary discussions with Mr. Rola's office, and so we're aware of the charges. We also understand what the bond recommendation is, and if it is what I understand it to be, we would have no objection to that.
All right, Ms. Bruker, as to bond, is there any additional information you want to give me?
Mr. Rolla did a plea sheet, Your Honor. Defendant does not have any criminal history, so we are requesting that the court order the standard terms of bond, that he not leave the state without permission, that he attend each and every court hearing, and that he not commit additional crimes while on release. We also request that he report to community corrections and follow the recommendations, and we are requesting a $2,000 PR bond.
Mr. Blumberg, anything else you want to add?
Yes, my understanding is he has a summer home here in Michigan, but he's a resident of the state of Ohio, where I believe he spends the majority of his time. So the prohibition of leaving the state, I think, would be problematic.
When does he intend to go back to Ohio?
Kevin, do you have immediate plans, or are you going to be in Michigan or in Ohio?
Well, it's mostly for my job. I do have to go to South Bend, Indiana, Fort Wayne, and Toledo. Those are along with the state of Michigan. I mean, so it's not a problem to stay in the state of Michigan. It's just those three areas are job sites that I have to go to occasionally. You know, the home in Columbus, like I said, that's a secondary home. But you know, as far as my job is concerned, that would be the three areas that I might need to visit occasionally. If not, you know, no big deal.
Where is your primary residence, sir?
It's here in Johannesburg, 6589 Honey Lane, Johannesburg, in Michigan. Our secondary home is in Columbus, Ohio.
And when you say occasionally you may need to go outside the state, what's the frequency with which you would need to do that?
Maybe like once a month.
Is that business that can be conducted via Zoom or via telephone or without actually having to physically leave the state of Michigan?
A majority of it is on Teams calls. There is occasional visits that I make to my managers and the folks that report up through me. But if that's a problem, like I said, I can just stay in the state of Michigan.
All right, Mr. Blumberg, any additional argument that you wish to make at this time as to that?
Judge, I can represent to the court that I've represented Mr. Lutke in a number of civil matters. He's a businessman, very successful, has no prior criminal record. So I think certainly the PR bond is appropriate. I don't know, apparently I don't know the frequency in which he leaves the state, but I can assure you he will appear for every court proceeding. I know him, he's an upstanding citizen, and this whole incident that brings him before the court, I think, was a misunderstanding.
All right. And I don't discount anything that either you or your client have said to me today. Typically, how we handle those sort of circumstances is on an as-needed basis. An attempt to reach a stipulation with the prosecutor is done, and that can usually be done relatively quickly if the dates and the times and the places of needing to go out of the state are known. And I would be happy to, if that's not available to you for some odd reason, hearing that on an ex parte basis on an individual, hey, I need to go to Columbus for today and tomorrow and the next day. I'll be back and here's the number I'm going to be at and here's where I'm staying, kind of thing. So I think we'll just do that as we would normally do it. I don't see any reason to have a decision on bond now in that regard. So I am going to set bond in $2,000 PR. The conditions on that bond, Mr. Ludke, are that you personally appear for any scheduled court date, that you abide by any judgment of the court, that you not leave the state of Michigan without the permission of the court, and that would be by the procedure that we've just talked about on the record, that you not commit any crime while on release, and that you immediately notify the court in writing of any change of address or telephone number. Ms. Bruker, any indication that alcohol or controlled substances were a part of this offense?
No, Your Honor.
Then I'm not going to impose any requirements for that in the bond either. Because this is a felony offense, Mr. Ludke, upon your release from the jail, you will need to contact Community Corrections. They are the agency that monitors people that are on felony bond for this court. It's simply a phone call and some conversation that you'd have with the Jessica Van Wolfen, who is the person who handles that for us in the jail, will give you that phone number upon your release. Any questions, Mr. Ludke?
No, Your Honor.
Mr. Blumberg, any questions?
No, Judge, but I'd like to thank Brent of your office. He's been incredibly cooperative and helpful in guiding me with Mr. Lutke's processing today. And I don't know if he gets praised enough, but I do appreciate his insight and help. Thank you.
I try to do my best in that regard, but I appreciate your efforts in assisting me. So thank you.
Thank you.
All right. Have a good day. That's all for today.
You too. Have a good weekend, everybody.
Thank you.
Rest these at the jail as well?
Yes.
All right. Mr. Ludke, if you could get the staff to process you there, we'll get this paperwork to you as quickly as we possibly can, but if you could ask them to bring in one of the next prisoners, please.
Yes, Your Honor.
Thank you.
I heard, Judge. Okay. Your Honor, we're gonna grab Mr. Hall next.
Thank you.
Yes, sir. Hey, just let him know he'll have adequate time to eat. Okay? So tell him to put his blood on his rack.
Mr. Roberts, good side. That's nice to hear. At least you did a nice job. I'm the best. Appreciate it.
And also I call dispatch and MSP more this week. Because they get so that MSP more assistance. So I'll make sure I'm copy. Okay, thank you. Okay. Come on, sir. All right. Right now, room right there, okay? I would ask you to state your name, let's go ahead. Pick it up so we can see you. Okay. All right.
Good afternoon, sir. Are you Robert Hall?
Yes, Your Honor.
All right. My name is Judge Hesselink. I'm going to call your case and then we'll get started. This is the state of Michigan versus Robert Hall. That's file 26-44729-FY. Mr. Hall, I'm going to arraign you. That means I'm going to tell you what you're charged with, tell you what your rights are, and then we're going to address bond. With me today is Richard Trusch as defense counsel and Amanda Bruker from the prosecutor's office. They're going to assist me in part of this process as well. Listen carefully as I read the complaint to you. It says that on or about July 17th of 2026 in the city of Gaylord and Otsego County that you did commit the following offense known as retail fraud first degree. It says, which reads that you did in a store or its immediate vicinity while Walmart was open to the public steal property of the store that was offered for sale at a price of $1,000 or more contrary to the Michigan compiled laws. That would normally be a felony offense with a penalty of 5 years and or a $10,000 fine. However, the prosecutor has also charged you with being a habitual offender, fourth offense, which says as follows, that you were previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about July 15th of 2014, you were convicted of the offense of delivery or manufacture of a controlled substance less than 50 grams in the 57th Circuit Court for Emmett County in the state of Michigan. And that on or about November 19th, 2008, you were convicted of the offense of possession of a controlled substance less than 25 grams in the 57th Circuit Court for Emmett County in the state of Michigan. And that on or about January 22nd, 2009, you were convicted of the offense of possession of a controlled substance less than 25 grams in the 57th Circuit Court for Emmett County in the state of Michigan. And therefore, the penalty has been enhanced up to maximum of life imprisonment because the underlying offense has a penalty of 5 years or more. In other words, the offense that you're charged with is called retail fraud first degree, and the maximum penalty is now, because of the habitual offender notice, raised to life imprisonment. Do you understand both of those things?
Yes, Your Honor.
As to that charge, you have the right to be tried in front of a judge or a jury. You have the right to be represented by an attorney, and if you cannot afford an attorney, one would be appointed for you. And you have the right to plead guilty, not guilty, or to stand mute. Your trial rights include the right to see, hear, and question the witnesses against you, the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. Your right to testify yourself or to choose to remain silent, and that silence would then not be used against you. The right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. And finally, the right to appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
All right. Mr. Trush, have you had a chance to speak to Mr. Hall about his right to an attorney?
I have. He has been screened and approved for a court-appointed counsel.
All right. Mr. Hall, I'm going to send your request for court-appointed counsel to the supervisor of that department, who will determine which specific attorney is going to represent you. In the meantime, I'm going to enter a not guilty plea on your behalf. And then because you're charged with a felony offense, I'm going to set a couple of quick court dates also to protect your rights. The first is called a probable cause conference. That's an opportunity for your attorney and the prosecutor to meet and discuss the case and see if they can resolve it quickly. That'll happen within the next 7 days. The next hearing is called a preliminary examination. That will happen within the next 21 days. That's right. Hearing in front of me is the district court judge, where the prosecutor is required to prove a small amount of evidence called probable cause that you committed the crime that you've been charged with. It is not a determination of guilt or innocence, but a check on the system to see if there's sufficient evidence to proceed. You understand the hearings that we just talked about?
Yes, Your Honor.
All right. What we're going to do now is consider the issue of bond. So I'm going to listen to both of the attorneys as they make recommendations as to that. Once you've heard what they have to say, I'm going to ask you if you have anything else that you want me to be aware of before I decide what to do. Ms. Brucker, your comment on bond.
Your Honor, the allegation is that defendant entered Walmart approximately 15 times over the course of a period of time and stole trading cards and other items totaling around $1,100. Defendant has a pretty lengthy criminal history, including convictions for retail fraud third, retail fraud second, larceny in a building, and various controlled substance related convictions. We would be asking for the court to order that he not re-enter the Walmart store, that he report to community corrections and follow the recommendations, and that he file the other standard terms and conditions of bond. And we are asking for a $5,000 10% or cash or surety bond.
Thank you. Mr. Trush, your comments?
Thank you, Your Honor. In regards to his history, there is some prior history here, obviously some outlined in the complaint. He reports to me that he does have a couple misdemeanors as well, which is consistent with what the prosecutor reported. None of the offenses that were listed by the prosecutor on the complaint contain any allegations of violence. He has strong connections here to the community. He's lived in Gaylord since 2017. He rents a home here. He participates in the medically assisted treatment program here. So he does have, he participates in the methadone program. He has a job. He is a painter. He's in his busy season right now. He reports, and in the past, he's always appeared for court, and he does have family in the area. He has a daughter at home, as well as his fiance and her 2 kids. So when the court considers the 2 factors the court is to consider when setting bond, safety of the community and likelihood of appearance, I think both of those cut in favor of a low bond here. Again, no violent history, no violence alleged in this offense would suggest that danger to the community can be mitigated. And his strong connections to the community, again, suggest that he is a good candidate for a bond. The $5,000 10% bond would seem appropriate given the circumstances. Thank you.
All right, thank you. Mr. Hall, I'm going to ask you in a minute if there's anything that you want to add to that. I'm simply going to caution you not to say anything about the facts of this case because we are recording this and that might be used against you later. But is there anything that you want me to be aware of in addition that relates to bond? If so, this is your opportunity.
No, I would show up for court. That's about it.
All right, thank you, Mr. Hall.
You're very welcome.
This is because of the habitual offender notice, this is a serious charge because it does carry a very high maximum penalty up to life imprisonment. I know that all the attorneys are aware that that doesn't necessarily mean he's going to get life imprisonment, but it is a high likelihood that he's going to get some prison time if he were to be convicted of this. And because of that, I do have to treat this a bit more seriously than as if he were a first offender and this were only a retail fraud charge against him. However, it does appear that the prosecutor's office recommendation is appropriate given not only his lengthy criminal history, but the fact that this is not a violent crime as noted by defense counsel. So I will follow that recommendation and indicate $5,000, 10%. Which means, Mr. Hall, that you will need to post $500 before you can be released. The conditions upon your release also include that you appear for any scheduled court dates or all scheduled court dates, that you abide by any judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while on release, and that you immediately notify the court in writing of any change of address or telephone number. Ms. Brucker, is there any evidence in this case that involves the use of alcohol or controlled substances?
No, Your Honor.
Then I will not require any of those in the bond procedure as well. I will follow the recommendation that Mr. Hall not enter into the Gaylord Walmart on the Idlewild Village Parkway in Gaylord, and that he must contact Community Corrections upon his release at the number that's available from the jail, as that is the agency which monitors people that are on felony bond. So you must do that upon your release. Mr. Hall, do you have any questions about anything that the court has ordered today?
No, sir.
Mr. Trush, any questions?
No, Your Honor. Thank you.
All right, that's all for today then. Thank you very much, Mr. Hall.
Thank you, Your Honor. Is there a way that? Yeah, we'll do that afterwards. Oh, They're waiting for you. Something's going on.
Can I have your name, sir?
Bill Ashton.
All right, Mr. Ashton, I'm going to call your cases. This is the state of Michigan versus Cale Ashton. There are two files. First is 26-44728-FY-3. The second is a similar case number 26-44725-FY-3. Both of them are set for arraignment. Mr. Ashton, my name is Judge Hesselink. I'm coming to you from the district court. With me is Mr. Truce from the defense and Amanda Brucker from the prosecutor's office. Please listen carefully as I tell you what you're charged with, tell you what your rights are, and then set bond in both of these matters. In the first case I'm going to address, which is 44725, the charge is as follows. On or about May 17th of 2026 in Corwith Township of Otsego County, that you did commit the offense of malicious destruction of personal property, $1,000 or more, but less than $20,000. That reads that you did willfully and maliciously destroy or injure a metal road gate, the personal property of Chad Benjamin Sides, and the amount of the destruction was $1,000 or more, but less than $20,000, contrary to Michigan compiled laws. That is a felony offense. It has a maximum penalty of 5 years and or a $10,000 fine, or 3 times the amount of destruction or injury, whichever is greater. Do you understand the name of that offense?
Yes, sir.
You understand the maximum possible penalty for that offense?
Yes, Your Honor.
As to that offense, you have the right to plead guilty, not guilty, or stand mute. You have the right to be represented by an attorney, and if you cannot afford an attorney, one would be appointed for you. And you have the right to have a trial in front of a judge or a jury. Your trial rights also include the right to see, hear, and question all the witnesses against you, to present your own witnesses and evidence, and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you also have the right to testify yourself or to choose to remain silent. And if you remain silent, that silence cannot be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, your trial rights include the right to automatically appeal any error. However, if you enter a plea in the future, you'd be limited to asking for permission to appeal, and that might not be granted. Do you understand those rights that I've just given to you, sir?
Yes, sir.
Do you have any questions about any of those rights?
I'm sorry, what was that, Your Honor? You're cutting out really bad.
Do you have any questions about those rights?
No, sir.
All right. Mr. Truce, have you had a chance to speak to Mr. Ashton about his right to an attorney?
I have. Mr. Ashton would qualify for counsel on these. I would indicate he did express to me that he's not sure if his father is planning to retain counsel for him or not, but he will qualify for appointment of counsel.
All right, Mr. Ashton, I'm going to appoint an attorney for you, but if at any time in the future you wish to retain your own attorney or your dad wants to do that for you, you have the right to do that, and you simply need to inform that court-appointed lawyer that the other attorney is going to switch in and take over at that point, and the attorneys know how to get the paperwork done for that process. Do you understand? I think we're having some technical difficulties with our connection with the jail at this point. You lose them?
You're still on.
Hello?
All right, you still there, Mr. Ashton?
Yeah, I'm sorry. I'm cutting back and forth out. Signals losing.
Yeah, we noted there's a connection problem.
Okay.
Basically, what I wanted you to know is that you can get your own attorney anytime that you wish.
Yes, sir.
And the two attorneys will know how to substitute in for each other. Do you understand that?
Yes, sir.
All right. You also, all right, go ahead, ma'am.
We're good.
Nope, you good?
Yeah.
Okay.
All right, thank you. All right, Mr. Ashton, you also have the right to have some quick hearings set in order to protect your rights. The first one is called a probable cause conference. That's a chance for your lawyer and the prosecutor to get together quickly and try to resolve the case if they can. Okay. That'll happen in the next 7 days. After that, within 21 days, you have the right to have a preliminary examination. That's a short hearing in district court where the prosecutor has to prove a small amount of evidence called probable cause that you committed the crime that you've been charged with. That is not a determination of guilt or innocence, but just a check to make sure that there's sufficient evidence to proceed with the case. Do you understand what I've told you about both of those hearings?
Yes, sir.
All right. What I'm going to do right now is simply enter a not guilty plea on your behalf in order to protect your rights and give you an opportunity to meet with that attorney that's going to be representing you in the future. We're now going to turn our attention to the, well, let me do this. I'm going to arraign you on the, no, we'll do it one at a time. I was going to do both cases and then go ahead, but I'll do the bond in the first case first, and then we'll move to the second case. I'm going to listen to both of the attorneys as to their recommendations as to bond, and then I'll give you an opportunity to say anything else after you've heard what they have to say. Ms. Brucker, on this case, what is your bond recommendation?
This is the MDOP or is this the RNO?
This is the MDOP.
Okay, and it's the MDOP, Judge. The allegation is that he and another young man trespassed onto some private property. In the process of leaving, he intentionally crashed his vehicle into a metal gate, causing around $2,000 worth of damage. He does not have a criminal history, so we'd be requesting for terms of bond that he not have contact with Chad Sides, who is the owner of that property, that he not re-enter the property at 8431 Fontanales Road, that he report to community corrections and follow the recommendations, and that he have the other standard terms and conditions of bond. And we would just be requesting a $2,000 10% or cash or surety bond.
Thank you. Mr. Trush, your comments?
Thank you, Your Honor. As the prosecutor indicated, Mr. Ashton reports to me he has no prior history. He's been a lifelong resident of the community. While he did report to me that at present he is unemployed, he is physically capable of working and looking for work. He reports that he does rent a home in the area. I think that he has strong connections to the community and a lack of history. I would suggest to the court, I think a low cash bond is appropriate. I would ask court to consider a 1,010% bond, especially considering that we're going to be setting another bond here in just a moment.
All right. Well, I'm going to do a little bit different than both of the recommendations. Well, let me do this. Mr. Ashton, is there anything else that you want to add? I would simply caution you not to make any statements about the facts of the case because we are recording this and it could be used against you. But is there any other information you want me to know that relates to bond?
I don't think so.
All right. Thank you, sir. As I began to say, I'm going to do a little bit differently on this case because it is a non-violent offense and just involves property damage allegation. So I'm going to set a personal recognizance bond in this matter because we are setting bond in the other case as well. And I'm going to set that at $2,000. What that means, Mr. Ashton, is that you do not owe any money up front on this bond. But if you fail to appear or if you take action that's found to be in violation of the bond conditions, then you would owe a total of $2,000 on this file. Do you understand that?
Yes, Your Honor.
All right, and the conditions for that bond are that you appear for any scheduled court date, that you abide by any judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while on release, and that you immediately notify the court in writing of any change of address or telephone number. Ms. Brucker, is there any indication of alcohol or illegal controlled substance use in this file?
No, Your Honor.
All right, I will not use those as bond conditions then. I will, however, require that Mr. Ashton not have any contact, direct or indirect, with Chad Benjamin Sides, and that no contact order means in person or by other people on your behalf. It means no telephone, no computer, no social media. No contact means no contact at all. You also may not enter or be within 50 feet of him and his residence and his place of employment, and that includes 8431 Fontanales Road in Gaylord. And because this is a felony offense, you must contact Community Corrections upon your release from jail. And that is the agency that monitors people that are on felony bond for the court. And the jail has their telephone number that you'd be required to call within 24 hours. You understand all of that?
Yes, Your Honor.
All right. Any other questions that you have, sir?
No, sir.
All right, we're now going to turn to the second file. This is file 44728. And let me read that charge to you as well. This charge says that on or about July 16th of 2026 in City of Gaylord and Otsego County, that you did commit the offense of police officer resisting and obstructing. That reads that you did assault, batter, wound, resist, obstruct, oppose, or endanger an officer, Officer Seahuff, a police officer with the Gaylord City Police Department, who the defendant knew or had reason to know is performing his or her duties contrary to the Michigan compiled laws. That is a felony offense. It has a maximum penalty of 2 years and or a $2,000 fine. You understand the name of the offense with which you have been charged?
Yes, Your Honor.
You understand the maximum possible penalty for that offense?
Yes, Your Honor.
All right. You have the exact same rights as to this file that I explained to you on the other files. You have the right to have an attorney, you have the right to have a trial, you have the right to enter a plea, all of the same trial rights that I just got done talking to you about on the other case today. All of those apply to you in this case as well. Do you understand all of that?
Yes, Your Honor.
Do you have any questions about any of that?
No, sir.
All right, Mr. Truce, I assume that he qualified for court-appointed counsel in this case as well?
He does, Your Honor.
All right, I will appoint that process for you. And again, if you want to retain your own or have a family member help you retain your own attorney, you're welcome to do that in the future. But just so that you have the speedy opportunity to speak with an attorney, I'm going to appoint an attorney for you and allow that process to weigh itself out. I'm going to enter a not guilty plea on your behalf in order to protect your rights. We'll set that same probable cause and preliminary examination hearings for you as well, just like we did in the other case